Please note that this presentation, as well as the slides, are copyright protected, and therefore that any unauthorized distribution is strictly prohibited. We are sharing with you for educational purposes and in good faith, and ask that you respect that. My name is Nicoline Skumanlo, and I will be your presenter today. I'm an attorney, conveyancer, notary public, and mediator. I practice as such at Skuman Law Incorporated, based in Cape Town, South Africa. Now, let me start our discussion today with an analogy that I found to be extremely useful and very relevant over the years as I've been doing workshops and training sessions. And that is the analogy between legal solutions design and the art of baking. Now, for anyone with a culinary interest, you will know that baking is a very precise and very exact exercise. It is very much in the detail. Now, in the same way, legal solutions are very much in the detail. And there's a distinguishing factor between the core ingredients giving a dessert or a cake or a cupcake its nature. In other words, the core ingredients that need to be in there in order to make it a cake, a cupcake, or some other form of a dessert. Now, similarly, contracts have core ingredients giving them their specific identity in the context of a transaction. Similarly, if we talk about decorating the dessert by using icing or food coloring or sprinkles, for example, those are the additional things not really giving it its identity, but making it, in the baking context, more pleasant, more pleasuring to the eye, more enticing to eat. And then, of course, in the legal context, those are the things that really distinguish a elementary agreement that ticks the basic boxes from a really powerful legal design solution, a professional, valuable solution to a problem, or in reaction to constructing a transaction in the very best and potentially smartest way possible. Without any further ado, let us get to the essential ingredients required in order to make a JV or joint venture agreement come into existence, but also some best practice tips. Now, first and foremost, you would need to establish or decide whether this would be an agreement between individuals or between juristic persons or entities, or a combination. Then to decide what the purpose and objective of the joint venture is going to be. Will it be confined to a particular segment of the market, for example, or will it be confined to a specific type of work, or will it be a specific single project? Then, of course, the important commercial bit: how are we splitting profits and losses and bearing risk? How are we dealing with the decision making or the management of the joint venture? And then last but not least, how long is this going to persist, and how are we going to deal with anyone who breaches the agreement or commits an act of default? And then, of course, any disputes. So in unpacking the first component, the parties to the agreement, first and foremost, the agreement can be constituted between individuals or between business entities or juristic persons, or of course a combination of the two. However, as attorneys, we often refer to the JV agreement or the joint venture as a corporate partnership. And of course, this alludes to the fact that we prefer it to be between business entities. And the reason for this is really because the minute two individuals or more would contract in this way, you are always running the risk of constituting something a little different from what you may intend, and it may actually then constitute a universal partnership and have far-reaching legal implications. So for that reason, we do urge you to use the JV as a corporate partnership agreement. And then, of course, it is important to align your interests, to find common ground, to find that synergy and growth possibility, not just for one of the parties, but ideally from a sustainability point of view for both of them. And to remember that the exchanges during the course of this existence, not just the constitution, but the existence of the agreement, would result in the exchange of highly sensitive information that could be exploited in an unfair and unlawful manner. And then, of course, not to lose sight of the fact that in this context, even POPI does apply to both the entities, and that they would need to reciprocally give undertakings to protect each other's data and to ensure that reasonable steps are taken in order to ensure that no client or third party is exposed through the interaction of either or both of these organizations with one another. Now that we have dealt with the whom, it is quite critically important for us to look at the object and purpose, or let's say the strategic objectives of the joint venture or collaboration. And I cannot reiterate this and focus on this enough. It is critically important for you to be very specific on the market segment or the project or type of projects in significant detail that will be segmented or focused on by the joint venture. And the reasoning behind this is actually quite simple. Think about it. Either party wouldn't want a perception to exist that one of them, to the exclusion of another, has exploited an opportunity. And of course, it can only, if that were to happen, end up in one place, and that is a dispute situation, which we are seeking to avoid. So be very clear on what will be segmented or reserved for pushing through the joint venture. Be very clear on what you're seeking to achieve with it. Now, besides focusing on a particular segment of the market or a particular project or a type of project, let's be very clear on what we are actually trying to do here. And that would mean that you need to be clear on why you need to enter into this agreement or why you are looking at doing this. Is it because you want to expand into a different segment of the market or a particular offering that you are not strong in or you don't have capacity in? Or perhaps it is a compliance consideration. Perhaps you are seeking to bid for a contract that has very specific prerequisites needing to be met. Now, regardless of the reason, it is very important that you know what the reason is and that both of you are absolutely clear on this and that there's a shared objective, a shared advantage, not a unbalanced situation. So firstly, to be clear on what type of work will be channeled through this entity, and secondly, on what we are strategically seeking to achieve by this. Now let us look at the commercial side of this. And this is where the number crunching will be quite critical even before you have signed on the dotted line.